Good afternoon, Your Honor.
Hey, good afternoon. How are y'all doing today?
Doing good.
Very good. We are live on YouTube so we can comply with open courts. I haven't done this in a while. I'm surprised I remembered how. I did have to look up passwords, but apparently it's working. So, all right. We are here on Sewak versus Citywide, and both parties are agreeable to go forward with this hearing by Zoom. Is that correct?
That is correct, Your Honor.
Yes, Your Honor.
All right, fantastic. This looks like this is a consent final order approving the settlement, certifying the class for settlement purposes, awarding attorney's fees, and dismissing the action. I will let y'all go forward.
I'll start. My name is Robert Friedman at Weatherington Law Firm on behalf of the named class representative, Ashley Sewak, and the preliminarily certified class of similarly situated persons. So we are here on the case of Sewak versus Citywide Parking Services, LLC. So some brief background from the court because it's been a while. So this action was originally filed back in 2020 and was originally two actions. Uh, Even more background, going back even further, this is not particularly relevant specifically to this case and this motion, but it provides context for the rest of what I'm going to tell the court, just to understand how we arrived at where we got, and why this case is a little bit different than some of the others. So my firm, starting in about 2016, 2017, began filing class action lawsuits against just about every vehicle immobilization company, and that's a booting company in the state of Georgia. They apply if you are not familiar with it, it's one of those yellow boots to a car wheel, and that immobilizes the vehicle, and it's done allegedly to cars that are trespassing, and you're supposed to pay a fee, and you'll get the boot off. Now, in Georgia, there is no OCGA statute that authorizes booting in the same way that you have one for towing. There is a statewide statute for towing. We have been trying to change that for the better part of, geez, it's been a long time, almost 6 or 7 years now. It's currently still in the legislature, and we're hopeful this time, but who knows? Either way, currently, and at the time of this lawsuit and the others, there was no OCGA statute for booting. So booting is primarily regulated by municipal ordinance or county ordinance. And in the absence of a municipal or a county ordinance, booting is strictly unlawful. And we know that there is no common law right to boot because in the pendency of these various different booting lawsuits, one of them eventually went to the Georgia Supreme Court, not this one, at which the Supreme Court determined that there is no common law right to boot.
Counsel, let me stop you. You don't really have to go into too much of this. This is an uncontested motion, I understand. And if you want to lay out what is requested, I think we can move forward.
Understood. Like I said, I was just providing some context, but I'll move into this case now. So with that in mind, this lawsuit was filed in 2020 against a booting company called Citywide Parking Services for allegedly booting vehicles originally in Marietta, Georgia, and later in Sandy Springs, in violation of the vehicle immobilization ordinances that those cities have. And specifically, these are related to sign violations. You have to have certain signage in order to boot vehicles. When we filed this lawsuit, we agreed with counsel shortly thereafter to engage in informal class discovery to figure out the size of the class, investigate the parking lots, and determine available potential insurance coverage. It took a long time to do that, a couple of years, but once we did, we eventually reached a settlement agreement, consolidated the cases in front of this court, and filed a preliminary settlement agreement back in September. And we filed it in June of 2023 and received preliminary approval from this court on September 15th, 2023 for the settlement, providing each of the class members a little bit more than half of what they paid, $45 per class member, 34% of attorney's fees of a class pool of a little bit over $300,000. And since that time, the case went into class administration with Atticus administration. We extended the period once, and from there, we were able to achieve about, and this depends on how you count conservatively, we have about 3.35 as documented in the declaration of Mr. Brindley, which is Exhibit 1 to the motion for fees that we filed. We have 3.35% class members participating in the class with about 265 claim form submissions. And the average claims rate, as stated by Mr. Brindley, the class administration for national class actions, is somewhere between 2.9 and 3.5. So we're about in the middle. I will say that if you look at the class a little bit differently in terms of what we actually had was about a little bit close to 8,000 class members total. But the truth of the world is that number was really boiled down to about 4,213 once they ran skip traces and were only able to literally find addresses and phone numbers for about at most 4,213 of them. So the reality is that 3.35 number is conservative, whereas the reality is the true participation rate of the people that were identifiable is a little bit closer to something close to 6%, which is pretty good. Like we're beating the national average by a reasonable amount. People are getting more than half that applied for the settlement of what they paid for the booting. The total settlement pool was $355,905. Of that, we are requesting 34% as attorney's fees, no case expenses, and a participation award of $2,500 for a total attorney fee award of $121,007 and $2,500 as a class participation award to Ms. Sewak for her being the participating class member. I'll rest on my brief to save the court time, but we filed and documented time, labor, and effort that went into this. I will point out that we're not requesting an hourly fee. Awards for attorney's fees and class actions are not awarded based on hourly fees, but we have estimated the time that we put in to show that this was not a simple matter and to satisfy the requirements to show that the fee is reasonable. And our position is that based on the documents, the pleadings, and the result we obtained, 34% of the class pool here, we believe is a reasonable fee.
Thank you. Counsel, do you have anything to add?
No, just Taryn Kadar for the record, on behalf of Citywide Parking. Yeah, this is a non-contested motion. We've already kind of gone through most of the action points needed. So at this point, we're waiting for kind of rubber stamp and we can move forward and get the class administrator to start distributing the funds and get this fully finalized and resolved, which my client would be very happy to put this all behind them.
All right. Very good. Well, I do have, of course, the order that goes through and sets out each of the points that you have covered here today, as well as many others, including dismissal with prejudice. We will get this executed and filed in, and it will be served upon you by email shortly. So you can expect it this afternoon.
Thank you, Your Honor.
Okay.
Perfect. Thank you. We appreciate it.
Thank you very much. Thank you for appearing by Zoom.